Right, good morning, everybody. We had a slight delay with the usual IT problems that seem to besiege all of us nowadays, but we're ready to go now. Welcome to the Countryside's Right-of-Way panel. It's Friday, the 14th of July, 2023. Could we start, please, with apologies?
Apologies, Chair, from Mr Pritchard and Mr Hudson.
Thank you.
Can I probably put Mr Waring, please, because we know her health is not great, so in case she's...
Yeah, I think Jill Waring's got sort of a long-term sickness problem. Okay, is that noted?
Thank you, Chair.
Brilliant. And item number 2, declarations of interest. The only one that I've got myself is a personal interest in so much as one or two of the landowners in item number 6. I do know them, but they're not friends or anything like that, but just for clarity and to make sure that we do things properly on this panel. And can we move on to item number 3, which is minutes of meeting held on the 23rd of June. I presume you've had a chance to look at them. Thank you. Moved? Agreed? Okay, thank you. And item number 4 is the S53 application for upgrading to a restricted byway of part of the public footpath 12 at Grindon Parish between Fleets Lane and BW6 Grindon. Is this Hannah? Thank you. Could you give us the report?
Of course. Thank you, Chair, members. So, yes, this is an application to upgrade part of public footpath 12 in the parish of Grindon, specifically between Fleets Lane and public bridleway number 9 to a restricted byway. The application was submitted by Stafford Moorlands Bridleways Group and was submitted based on historical evidence. The original evidence submitted consisted of ordnance survey maps, an ordnance survey manual and a 1929 handover map for the area of Leek Rural. So if I start with the evidence, if we look at the 1929 handover map, so this shows a route running along the same line as the alleged route, and the route is marked in a turquoise colour. There is no key or list with the map, so no indication as to the status of the route. Just to provide a little bit of background, under the Local Government Act 1929, the responsibility for publicly maintainable highways was transferred to county councils from district councils. This led to lists being created which recorded the routes that had public maintenance liability, and these became known as handover maps. The term unclassified county roads came to be applied to these routes. This moniker has no legal status. The handover map is only concerned with liability of maintenance, not with the type of public user. Therefore, this document only supports the route's physical existence as a public right-of-way, as it shows liability for the route, but it does not attest to the nature of the public rights. When looking at the 1-inch ordnance survey map, again, this shows the physical existence of the route, but it does not identify the nature of any rights over the alleged route. The 25-inch ordnance survey map and the ordnance survey manual need to be reviewed in conjunction. So the map shows a carriageway adjacent from separate land holdings, running past several plots of land along the same line as the alleged route. The OS map has benchmark numbers depicted alongside the route, and the section of the manual provided by the applicant refers to primary levelling and benchmarks. So, Ordnance Survey benchmarks are survey marks made by Ordnance Survey to record height above Ordnance datum. Therefore, the purpose of benchmarks is not to distinguish or depict the status of routes shown on the map, but merely to represent height. The numbers depicted on the Ordnance Survey map relate to the description of the benchmark set in the manual. So the numbers depicted along the alleged route do seem to match the benchmark levels that were given to service heights that were shown along routes that were classified as roads. So whilst there is a reference number given to show the benchmark level shown along roads from the Ordnance Survey Manual, this cannot be taken as strong evidence of the status of a route, as this was not the primary purpose of benchmark levels. It perhaps provides some supporting evidence that the alleged route may have been a road, but a road is a highway which does cover footpaths to major highways. If we now consider evidence that has been submitted by landowners affected by the application route. So 2 landowners were identified as part of the application. Both landowners advised that they consider the route to be a footpath and footpath signs are in place. One of the landowners advised that land affected by the application route is used as a wildflower meadow and is managed by Natural England for conservation. Concerns were also raised about disturbance to livestock along the route. Just to make the point, whilst it is not our intention to belittle any legitimate concerns raised by any party, the courts have decided that issues relating to safety, security, privacy, suitability, future maintenance and wildlife concerns cannot be taken into consideration when determining whether a public right-of-way exists or not. So only evidence regarding the existence or not of a public right-of-way can be taken into consideration. The Byways and Bridleways Trust also responded to the application, advising that they do consider the route to be a road, which was used regularly in the 1970s and 1980s by members of the North Midland group of the TRF. So on circulation of the draft report, the applicant did submit further evidence. This included several Ordnance Survey maps depicting the route as a minor road and unfenced in parts. So again, this supports the physical existence of the route and does provide some supporting evidence of the route potentially having higher rights than a footpath. However, typically Ordnance Survey maps are not considered to be evidentially strong pieces of evidence on their own. Officers obtained a copy of the parish survey card for public footpath 12 Grindon. This shows that the path was recorded as CRF footpath. In the description section of the card, the alleged route is referred to as a footpath. So the parish survey card is supportive of the route being a public footpath. There is no mention or suggestion of higher rights over the route. The applicant also submitted a waterfall tithe map which depicts the current D1129. The route stops at the parish boundary between Grindon and Waterfall. Officers had the map geo-referenced onto current day mapping, and this has shown that the route on the tithe map would connect to the existing public bridleway number 9 Grindon. But the Waterfall tithe map does not actually show the alleged route. Officers have viewed Grindon tithe map dated 1839. This shows the section of public footpath 12 Grindon that has been applied for, and this is depicted as 2 broken lines running parallel to each other. There's no suggestion from the Grindon tithe map that public footpath 12 Grindon is a public road. Therefore, officers contend that when all the historical evidence is considered, the evidence is not strong enough on the balance of probabilities to show vehicular rights over the alleged route. In addition, 2 user evidence forms were also submitted from members of the public claiming to have used the alleged route. The user evidence submitted is not sufficient to meet the relevant legal tests either under statute or common law. Comments were also received from Grindon Parish Council objecting to the application, although they did also confirm that they had received comments from local residents who do support the application. So when we consider the legal tests relevant to this application, I think it's important to note that what is not in dispute is the fact that the route is a public highway, as it currently exists as a public footpath on the definitive map. So the question relates to the status and nature of the public rights over the route. So the evidence needs to be considered on the balance of probabilities as to whether the evidence shows the existence of vehicular rights over the alleged route, and therefore that the current classification of the route as a footpath is wrong. So to summarise, the 1929 handover evidence supports the public nature of the route, but it does not provide any specific evidence as to the nature of the rights over the route. The evidential value of Ordnance Survey maps is considered relatively weak when considering the nature of rights over a route. Therefore, to conclude, when all of the documentation is reviewed together, it does not support the contention on the balance of probabilities that the route has vehicular rights over it and that the route should be reclassified to a restricted byway. Therefore, Officer's recommendation is to reject the application and for no order to be made to upgrade the route to a restricted byway. Thank you. I'm happy to take any questions.
Thank you, Hannah. Have we any questions from members? Could I ask one minor question, really? You mentioned the TRF group used it for a few years. What's TRF stand for?
Sorry, apologies, I don't have the definition of that to hand. But I believe it's to do with transport route of the route, the way it was used. I can get the definition for you. Unfortunately, I don't have it to hand at the moment.
Paul?
Yes, there's no questions. I'd like to thank Hannah for the report. Balance of probabilities doesn't show that it should be a restricted byway. All the evidence is there. If we go back to the various maps and the handover in 1929, Ordnance Survey maps are really there for height and, as it says, for ordnance, for the army to move things from point A to point B. So on the balance of probabilities, I don't think the case is made out. It should remain as a highway, as it is, as a public footpath, and we shouldn't upgrade it, and therefore it shouldn't be put onto the definitive map. And that's my proposal.
Thank you, Paul. 2 seconds, please.
Apologies. I believe the definition for TRF is Trail Riders Fellowships.
Right, thank you. So I presume it's motorbikes, by the sound of things. It could be anything, but it's not a transport group per se.
No. In the evidence, it wasn't clear specifically how the route was specifically used, other than there was the suggestion it was used by vehicles of some sort in the 1970s and 80s, but in the evidence it wasn't elaborated on as to what, in the way the use was specifically.
Thank you. There was, in my teens, lots of little groups that sort of used to go off on their motorbikes and actually caused more problems than they solved. So thank you for just putting clarity on that one. We've got a proposal from Paul, a seconder from David. All in favour of the... Okay, we'll go with the officer's recommendation. Thank you very much, Hannah. We'll move next on to item number 6, which is the application for the addition of a public footpath from the B5026 to the highway at Oxley's Chebsey, LJ12GB. As I said earlier, the Chebsey ones, I'm just putting a personal interest in, as I know the farmers around there obviously being part of the farming community. Paul?
On all the next reports, 5 to 8, it's the county councillor is Jeremy Pert. Have we had any representations from the county councillor?
Thank you. No representations at all.
Okay, thank you. Can we therefore move on to the presentation? Is this Anna or David?
Thank you, Mr. Chairman. Can I confirm that it's actually LJ612GB that is on first on the agenda?
LJ612GB is in front of me.
Okay, thank you. Okay, thank you, Mr. Chairman, members of the panel. I will move straight to the recommendation, which is that the evidence is sufficient to show that a public footpath may be reasonably alleged to subsist along the route marked A to B on the plan attached to Appendix B. The application rests on a North Staffs Railway Plan of 1898 and is supported by a near-contemporary Ordnance Survey map of 1901. In this case, the route is described within the bounds of Plot 27 as a public footpath. Clearly, this annotation is good evidence that the route was indeed both public and a footpath. Good evidence, that is, for the lower test of reasonable allegation. Furthermore, we have reference to one of the landowners being the parish council, almost certainly suggestive of a public right-of-way passing through the plot. That is, a route traditionally maintained by the parish. This is confirmed somewhat by the presence of other named landowners. Again, the limitation of railway plans is they only show the section of the route that was to be affected by the proposed railway itself. Therefore, typically, only one part of any route is expected to be visible on any plan. This is something your officers acknowledge, although it is not necessarily fatal to a claim based on reasonable allegation. And again, this, Mr. Chairman, is where the Ordnance Survey plans offer us a degree of clarity. Members will be aware that OS plans have absolutely no probity whatever when it comes to the alleged legal status of a route. They are, and have never been, indicative of status. However, they are good evidence of the alleged line of any route, and where we have a near-contemporary OS plan showing the full extent of a route, from highway to highway, and with the absence of any nearby adjacent routes, it is more likely than not that this is the route in question. Clearly, if a railway plan shows a section of the route leaving a highway and following the same line as that on the OS plan, then it is reasonable to allege that the status of that section of the route will be the same throughout its length. Of course, there are exceptions to all rules, but generally speaking, it is more likely than not that the status will be consistent from highway to highway. In this case, we have clear evidence that one section of the route is a public footpath and equally clear evidence of the full extent of the route from the OS plan. Turning to the landowner responses, we find that the NFU made representations on behalf of the landowner and stated that they strongly opposed any creations of new rights of way. Members will note that the comments here from point 40 of the report, where at point 42 we find statements more relevant to a claim on user evidence than on historical or documentary evidence. And although the landowner avers there is no purpose or necessity for the alleged route, these points cannot be taken into account by this tribunal of fact. As such, nothing turns on them. Following the circulation of the draft report, several objections were received from the relevant landowners, the following statement being received from landowner 2. And again, I will read this statement. I think these alleged footpaths should be extinguished because of the amount of stress and anxiety it causes landowners. Please put yourselves in our position. To find out that there is an application to reinstate a public right-of-way because it's shown on a map that's not an official record drawn over 100 years ago. Imagine this going down your driveway and past your kitchen window and through your garden. If this is allowed, it could open up the floodgates to further applications, and the next time it might be your land. If it is allowed, there should be new rules drawn up so that all alleged footpaths have to be declared by a certain date, e.g. 2025, given a couple of years for applications to be made before a deadline. Otherwise, it's impossible to buy land in the future and rest comfortable with the purchase on the information available and be comfortable investing and developing land where suitable. And again, there ends the quotation. Chebsey Parish Council, interestingly, were not supportive of the route and were unaware of any recent use, adding that it would be not be an asset to the local footpath network. This was at the time of the initial consultation, and their position remains unchanged in this regard. Following the circulation of the draft report, the Parish Council considered each of the applications separately, and it was agreed that the original response from the Parish Council, dated the 6th of July 1999, still stood. The councillors were in agreement that there would be no benefit to the parish, that there were concerns regarding the costs of opening up the footpaths and their upkeep, and the paths do not link into any existing network of footpaths, and in conclusion they stated, it has been 23 years since the last consultation and there is still no evidence of any benefits in opening the footpaths. There is no justification for them to be added to the definitive map. Conversely, the Ramblers Association supported the application, highlighting that Chebsey has a shortage of routes and going on to say that they supported any initiative to create or recognise public rights of way. Their only concern was that the route was not a more substantial one. What more can your officers say? This is essentially an addition on the lower test of reasonable allegation. We have a document indicating its status and a document indicating its extent. As such, officers believe there is enough to satisfy the lower test and to recommend that the application be accepted and an order made to add the route as a public footpath to the definitive map and statement for the Borough of Stafford. Your officers further recommend this should be to the minimum width of 1.5 metres throughout its length. Thank you, Mr Chairman. I'm happy to take any questions.
Thank you, David. Apologies before we go into questions. Obviously, I've skipped item number 4, gone straight on to number 5, which is why you asked which application it was. I'm sure everyone's picked that up, but that's the wonder of technology. So we're on. We've had the report from the officer. Have we any questions or clarifications needed? We have a recommendation. Does anyone want to?
I'll second David's proposal. I'll second it for the reasons put out there.
Okay.
We go then that it's put on the printed map and that it's 1.5 metres wide, as recommended by our officers.
Okay. So can we have a vote on it? Those in favour? Okay, that recommendation is passed, and we'll go with the officer's recommendation on that to accept this. And as I say, apologies. We'll go back to item number 4.
Back to 5, we've just done 6.
Oh, I've skipped 2, have I?
No, you've done 4.
Right.
You've done 4, the Grindon one. Then
Yes.
you skipped to 6, so we're
Right.
back to 5.
5. Okay.
Which is still Jeremy Bird. It's all Jeremy Bird now.
Yes.
So we're on RJ612A, Chair.
Yes, got that. So item number 5 is application for the addition of a public footpath from the B5026 to the highway to Chebsey, parish of Chebsey, LJ612A. That's correct, isn't it? It's one of those mornings. Apologies. Okay, is this you again, David?
Yeah, thank you, Mr Chairman. Members of the panel. I will move straight to the recommendation, which is that the evidence is sufficient to show that a public footpath can be reasonably alleged to subsist along the route marked A to B on the plan attached to Appendix B, and that an order should be made to add the route to the definitive map and statement for the Borough of Stafford. This was an application based upon historical evidence, and more particularly on the North Staffs Railway Plan of 1898, and was supported by 2 near-contemporary Ordnance Survey plans dated 1889 and 1901. As members will be aware, railway plans were produced by the railway companies for major schemes of work and were authorised by private acts of Parliament. From 1838, these plans and the associated books of reference were required to be deposited with the local public authorities and are now typically held by the relevant County Records Office. While they may provide only supportive evidence for applications considered on the higher test, the balance of probabilities, they can, in their own right, be sufficient as evidence in cases of reasonable allegation. As such, officers need to consider if there is enough evidence in each railway plan to suggest that the relevant route subsists. In this case, the route is described within the bounds of Plot 16 as a public footpath. Clearly, this annotation is good evidence that the route was indeed both public and a footpath. Good evidence, that is, for the lower test of reasonable allegation. Furthermore, one of the landowners was the parish council, almost certainly suggestive of a public right-of-way passing through the plot. That is a route traditionally maintained by the parish. This is reinforced by the fact that other landowners are named for the same plot. The limitation of railway plans is that they only show the section of the route that was to be affected by the proposed railway itself. Therefore, typically, only part of any route is expected to be visible on any plan. This is something that your officers acknowledge, although it is not necessarily fatal to a claim based on reasonable allegation. And this, Mr Chairman, is where the Ordnance Survey plans offer us a fair degree of clarity. Members will be aware that OS plans have absolutely no probity whatever when it comes to the alleged status of a route. They are not and have never been indicative of status. However, they are good evidence of the alleged line of any route, and where we have 2 near-contemporary OS plans showing the full extent of a route from highway to highway, and with the absence of any nearby adjacent routes, it is more likely than not that this is the route in question. Clearly, if a railway plan shows a section of the route leaving a highway and following the same line as that on the OS plan, then it is reasonable to allege that the status of that section of the route will be the same throughout its length. Of course, there are exceptions to every rule, but generally speaking, it is more likely than not that the status will be consistent from highway to highway. In this case, we have clear evidence that one section of the route is a public footpath, and the full extent of the route is revealed to us by the 2 OS plans. Furthermore, in this application, we have an additional piece of evidence in the parish survey card of 1951. This identifies a route following the same line as the alleged route, indicating that it started, quote, about 200 yards south-east of Oxley Sows Farm and finished at the sharp road bend about 100 yards from Smallwood Pit. The survey card has a corresponding plan which again shows very clearly the line of the route, and again this matches the route shown on both the deposited railway plan and OS maps. The description of the alleged route, identified by number 8 on the parish survey card, states that it is a continuation of the route marked 12, and that its reason for inclusion in the survey was due to usage. The parish survey card also noted that the rails were grown up and wired, suggesting the route had fallen into disuse by 1951 and that it was obscured by undergrowth. The phrase grown up or upgrowth refers primarily to green weeds growing up rather than more substantial woody overgrowth that typically hangs down from neighbouring trees. Undergrowth is more transient than overgrowth, and it is more subject to the seasons, and so its presence may have less impact on the use of any route than the heavier wooded overgrowth. In fact, the parish survey card states that the route was almost unusable in 1951, probably explaining why it didn't make it onto the draft and provisional definitive maps. Notwithstanding, the presence of the route on the 1951 parish survey card is good evidence of its existence and indeed ratifies the other evidence. Turning to the landowner responses, we find that the NFU made representations on behalf of the landowner and stated that they strongly opposed any creations of new rights of way. Members will note the comments here from point 50 of the report, where we find statements more relevant to a claim on user evidence than on historical or documentary evidence. And although the landowner avers there is no purpose or necessity for the alleged route, these points cannot be taken into account by this tribunal of fact. As such, nothing turns on this. Following the circulation of the draft report, several objections were received from the relevant landowners, the following statement being received from landowner 2. And I will now read this statement in full. I think these alleged footpaths should be extinguished because of the amount of stress and anxiety it causes landowners. Please put yourselves in our position to find out that there is an application to reinstate a public right-of-way because it's shown on a map that's not an official record drawn over 100 years ago. Imagine this going down your driveway and past your kitchen window and through your garden. If this is allowed, it could open the floodgates to further applications, and the next time it might be your land. If it is allowed, there should be new rules drawn up so all alleged footpaths have to be declared by a certain date, e.g. 2025, giving a couple of years for applications to be made before a deadline. Otherwise, it's impossible to buy land in the future and rest comfortable with the purchase on the information available and be comfortable investing and developing land where suitable. And again, there ends the quotation. Chebsey Parish Council, interestingly, were not supportive of the route, stating that they were unaware of any evidence suggesting that the path had been used in recent years and it would not be an asset to the footpath network. Following the circulation of the draft report, the Parish Council considered each of the applications separately, and it was agreed that the original response from the Parish Council, dated the 6th of July 1999, still stood. The councillors were in agreement that there would be no benefit to the parish, that there were concerns regarding the costs of opening up the footpaths and their upkeep, that the paths do not link into any existing network of footpaths, and that LJ612GA, this application, Mr Chairman, would be extremely dangerous due to the access onto the B5026. In conclusion, they stated it has been 23 years since the last consultation, and there is still no evidence of any benefits in opening the footpaths. There is no justification for them to be added to the definitive map. The Ramblers Association were, however, supportive of the route and highlighted that Chebsey seemed to be somewhat short of public rights of way. They went on to say that they supported any initiative to create or recognise public routes, adding that it was a pity that the route in question was not more substantial. Again, all these opinions, both for and against the route, are noted, although none adds anything of probity to the claim. The only relevant question relates to whether the alleged route subsists or not, and if so, whether any legal event has occurred to remove it. There is evidence for the former, but no evidence for the latter. Taking everything together, we have a clearly marked deposited railway plan supported by 2 ordnance survey maps and ratified by a parish survey card with plan. As such, your officers believe there is more than enough evidence to satisfy the lower test of reasonable allegation and recommend that the application be accepted and an order made to add the route with the status of a public footpath to the definitive map and statement for the Borough of Stafford. Your officers further recommend that the route should be to the minimum width of 1.5 metres where it was a field edge route, that is the southernmost section, and 1 metre where it was a crossfield route, that is the northernmost section. Thank you, Mr Chairman. Happy to take any questions.
Thank you, David. Quite a definitive presentation. David.
Yeah, Chairman, it was a comment really on something which he said within the evidence opposing the application. We're not creating a new footpath. We're only reinstating something which has been established as a footpath. We every time we have this panel meeting, we point out the fact that it's up to an applicant to make, or someone who suffers from an application to apply for a diversion. But I mean, our role is simply to recognise that that footpath exists and to give it its correct status. And we're not creating new footpaths, which I think is the main point, Chairman.
David, you're quite correct. It's as it says in the recommendation, to see if this application is a public footpath on the definitive map, so that we're just making sure the definitive map is correct and kept up to date. Paul.
It just really to go a stage further from what David has said. I'm hoping that the landowner too is watching us today, perhaps on Teams, whatever it is really. They should now take leave, if we decide, and we have a vote, to add this to the definitive map, they've got the right, as David has said, to make a request that it is diverted away from a kitchen window or wherever it is really. But we're acting on the 81 Act here, but there's other acts we go on which are historic. The maps are historic. Railway plans are going back perhaps 200 years. We're just adding what people have asked us to do because it's already there. We're not making new legislation. We're not making new footpaths. I just hope that if the objectors, the landowners are listening, just accept that we're here as a judicial body to decide what's been made hundreds of years ago, really, and I hope they accept that. It's nothing personal against them. We fear for them, really, at times, that their land is being changed, but it's been changed back to what it was years ago. There's no new orders going there, and I just hope that they accept that. And on this occasion, I will propose that once again we go with the officer's recommendation, that it's added to the definitive map as the footpath. It's 1.5 metres wide on certain sections. When it goes across land, it's down to 1 metre. And I will propose that.
We've got a proposal from Paul, a seconder from David. All those in favour of going with the officer's recommendation? Okay. Thank you very much for that. And correct me if I'm wrong, we'll move on to item number 7, which is an S53 application for the addition of a public footpath from the B5026 to the public path at the railway boundary, Chebsey, and that is application number LG612GC. I presume that's you again, David. Thank you.
Yes, thank you, Mr Chairman. Members of the panel. I'll move straight to the recommendation, which is that the evidence is sufficient to show that a public footpath may be reasonably alleged to subsist along the route marked A to B on the plan attached to Appendix B. The application rests on a North Staffs Railway Plan of 1898 and is supported by a near-contemporary Ordnance Survey map of 1889. In this case, the route is described within the bounds of Plot 13 as a public footpath. Clearly, this annotation, written by the surveyors, is good evidence that the route was indeed both public and a footpath. Good evidence, that is, for the lower test of reasonable allegation. Furthermore, we have reference to one of the landowners being the parish council, almost certainly suggestive of a public right-of-way passing through the plot, that is, a route traditionally maintained by the parish. Again, the limitation of railway plans is that they only show the section of the route that was to be affected by the proposed railway itself. Therefore, typically, only part of any route is expected to be visible on any plan. This is something your officers acknowledge, although it is not necessarily fatal to a claim based on reasonable allegation. And this, Mr Chairman, is where the Ordnance Survey plans offer us a degree of clarity. Members will be aware that OS plans have absolutely no probity whatever when it comes to the alleged status of a route. They are and have never been indicative of status. However, they are good evidence of the alleged line of any route, and where we have a near contemporary OS plan showing the full extent of a route from highway to highway, and with the absence of any nearby adjacent routes, it is more likely than not that this is the route in question. Clearly, if a railway plan shows a section of the route leaving a highway and following the same line as that on the OS map, then it is reasonable to allege that the status of that section of the route will be the same throughout its length. Of course, there are exceptions to every rule, but generally speaking, it is more likely than not that the status will be consistent from highway to highway. In this case, we have clear evidence that one section of the route is a public footpath, and the full extent of the route is revealed to us by the Ordnance Survey Plan. This application is complicated somewhat in that the original claim line ran to join public footpath 11 at the northernmost end of the alleged route. A diversion of this existing right-of-way was instigated by the landowner, Network Rail, after the application was made, which resulted in the line of public footpath 11 being relocated further south, and members will see this more particularly at Appendix G. If members were minded to accept the application, then the public rights at the northernmost section between the railway boundary and the current route of public footpath 11, points A1 to B on the plan at Appendix G, could be effectively extinguished when an order was made. This would ultimately prevent a dead-end route from being created and would fulfil the original aim of the application to join the route to public footpath 11. This would be a matter for discussion with the Rights of Way team should the application succeed, and it is not a matter for this tribunal of fact. Officers can therefore only highlight the importance of considering the full extent of the route from A to B at this stage of the process. Turning to the landowner responses, we find that the NFU made representations on behalf of the landowner following the initial consultation and stated that they strongly opposed any creations of new rights of way. Members will note the comments here from point 38 of the report, where at point 40 we find statements more relevant to a claim on user evidence than on historical or documentary evidence. And although the landowner avers there is no purpose or necessity for the alleged route, these points cannot be taken into account by this tribunal of fact. As such, nothing turns on them. Following the circulation of the draft report, objections were received from several parties. Landowner 1 stated, "I strongly object to these proposals. My interest is that I farm the land as a tenant and see the requirement for feeding the nation. The route A1 to B, is well serviced by the new footpath along the new railway. I do not believe the former footpath can be reinstated as its former route goes straight through a private dwelling at Scamnell. The unnecessary loss of production and time spent maintaining a footpath for very little use, no use in the last 100 plus years, was also added. I can't quite believe that the council are wasting taxpayers' time and money on such ridiculous ideas. My reasons may not fall into the required legal boxes, but common sense should prevail. There is new access which allows the general public to get where they want to without wasting valuable arable land." Landowner 2 stated, "I would like to oppose the proposed footpath. The footpath has never been walked. The footpath is not on any modern maps we rely on nowadays. The footpath is not on the definitive footpath map and so should not be reinstated. When I purchased my land, I had all the necessary searches done to clarify there was no footpath on my land, and if there had been, I wouldn't have purchased the land. If the footpath gets reinstated on my land, I would expect and proactively chase compensation. The footpath is also unnecessary and should be extinguished as it joins footpath 11, which is already there about 60 metres to the east going to the same place. This footpath 11 is a good path that is already there. This meaning less cost to the county council, which I'm sure is a good thing in the current financial climate with government debt. I think these 4 alleged footpaths should be extinguished because of the amount of stress and anxiety it causes landowners. Please put yourselves into our position to find out there is an application to reinstate a public right-of-way because it's shown on a map that's not an official record and drawn over 100 years ago. Imagine this going down your driveway, past your kitchen window and through your garden. If this is allowed, it could open the floodgates to further applications, and the next time it might be your land. If it is allowed, there should be new rules drawn up so all alleged footpaths have to be declared by a certain date, e.g. 2025, giving a couple of years for applications to be made before a deadline. Otherwise, it's impossible to buy land in the future and rest comfortable with the purchase on the information available and be comfortable investing and developing land where suitable. If the alleged footpaths are not extinguished, I agree with the northern part of the footpath that joins footpath 11 being extinguished, as footpath 11 has already been permanently diverted, and this then avoids leaving a cul-de-sac ending at the West Coast main railway line, which could be very dangerous, sending walkers down there and a security and health and safety risk to people and the trains, as it would leave a remote dead end. I also am aware that the footpaths have to have a public access at both ends, and this would not be the case if this northern part is not extinguished. Landowner 3 highlighted that the route would not be commodious to the public and that there were more convenient routes nearby. There was the suggestion that antisocial behaviour could be attracted to the area, and this may conflict with the activities of the neighbouring farms. Again, Mr Chairman, all of these objections are duly noted, although on scrutiny nothing turns on them. Members are, of course, able to consider them objectively. Chebsey Parish Council, interestingly, were not supportive of the route and were unaware of any recent use, adding that it would not be an asset to the local footpath network. This was at the time of the initial consultation, and their position remains unchanged. Following the circulation of the draft report, the Parish Council considered each of the applications separately, and it was agreed that the original response from the Parish Council, dated the 6th of July 1999, still stood. The councillors were in agreement that there would be no benefit to the parish, that there were concerns regarding the costs of opening up the footpaths and their upkeep, that the paths do not link into any existing network of footpaths, and in conclusion they stated it has been 23 years since the last consultation and there is still no evidence of any benefits in opening the footpaths. There is no justification for them to be added to the definitive map. Conversely, the Ramblers Association supported the application, highlighting that Chebsey has a shortage of routes and going on to say that they supported any initiative to create or recognise public rights of way. Their only concern, again, was that the route was not a more substantial one. This is essentially an addition on the lower test of reasonable allegation. We have a document indicating its status and a document indicating its extent. As such, officers believe there is enough to satisfy the lower test and to recommend that the application be accepted and an order made to add the route as a public footpath to the definitive map and statement for the Borough of Stafford. Your officers further recommend that this should be to the minimum width of 1 metre throughout its length. Thank you, Mr Chairman. Happy to take any questions.
Have we any questions?
So, can I just clarify? We had a situation in my division many years ago where, without any permission at all, a public footpath was blocked, which would meant that the public footpath would actually provide access across not only the A5 at a dual carriageway point, but also the M6 toll. And so clearly it would be not possible for that footpath to continue to exist. And I assume that the footpath here from, the section which goes up to the railway line, that would at some stage have continued across the land at that point and would have gone on to somewhere else. It seems to me that if we to approve the application, can we approve part of it and not the part which is a dead end? I'm not too sure whether I properly understood that, but it does seem to me that the dead end footpath isn't really a footpath from A to B, which is the purpose of a footpath.
Legal one for you, David.
Thank you, Mr Chairman. Yeah, in this case, and we do get several cases of this sort of nature, and officers would always recommend that we consider the entire extent of the route, and if an order was to be made, it would be made for the full length of the route. If we didn't do this, then we risk public rights sort of hanging around in abeyance, and the section of the route from A1 to B that joins the railway boundary, it still exists, but we've done nothing about it. So if we were to approve part of the route, we still need to deal with that section, in this case the northernmost section, that otherwise would just, it would be in abeyance, and it would give uncertainty to landowners going forward as to whether a future claim would be made on it. So to sort of clarify things and to sort of set the record straight, officers would recommend that if an order was to be made, at that time, an extinguishment would be made on the northern section rather than a part order being made just on the lower section.
I'm not too sure, Chairman. Now, are we in a position to only approve the first part of the application and not approve the dead-end section of the footpath? Because it seems to me somewhat silly for us to approve a footpath that goes to nowhere.
Just for clarity, and I think this was brought out in an earlier one that Paul sort of commented on, we are working on the definitive map, and the definitive map, if we pass this, will show this footpath. It then goes, it's then the responsibility of the landowner or the county to decide what they do with it after that point. Our job is to say, is the evidence there? And do we agree with the officer's recommendation, which I would say is the right way, and anything auxiliary that is mentioned is dealt with afterwards. But our job is to make sure that anything that goes on the definitive map is right.
Chairman, I accept that, but just going back to, 150 years or so ago, be a bagatelle, when the rail line went through, is there no evidence that the footpath at that stage ceased to be a definitive footpath and was closed? I mean, surely the railway company at that sort of stage would have done something about shutting off the footpath, and I'm surprised that the footpath still exists across a railway line. I don't know, Chairman.
Thank you, yes. In this case, the line of footpath 11 was originally sort of along the railway line itself. It sort of ran parallel, and it was moved further south, so it was actually moved away from the railway line, which sort of effectively bisected the application route. So in effect, this particular path, to the best of our knowledge, didn't cross the railway line. It met footpath 11, another public footpath, which did run very close and alongside the railway line. And by the railway actually diverting that further south, we now have the situation where this claim route actually joins footpath 11 much further south than it did originally. So it's not as if we're looking at the situation you just described. It's slightly different in that we're just looking at the relocation of an existing public footpath, and that our recommendation is to sort of consider the full entire length of the historical route. Of course, a part approval for part of the route would be something for the members to consider, and I believe that would be possible for them to approve if that was what they were minded to do.
Paul?
I mean, this application is 1999. Since 1999, we've had the toll road built. We've got this new road, HS2 coming. I think over the next 20 years, 30 years, when we're no longer on this committee, we're going to have similar things like this coming, where there's going to be a path going from A to B, the new road or whatever's going to come in the middle. But the path will have always been there. Once a highway, always a highway. It's never diminished, really. So I think really on this one, as David says, we've got to either authorise it all or none of it. And then once we've authorised it, it's then up to the landowner to come back and say they want something removed, which they can do legally, either have it diverted or whatever through the due process of law. But I think really on this occasion, we've got to go with officer's recommendation if we feel that the footpath was there originally, and then the full officer's recommendation, width, etc.
Is that a proposal?
Okay. Yes. I'm not saying it's going to lead to anything, but if it doesn't, it'll lead to things with the landowners, as David says, not knowing for the future whatever it's going to be. We've got to act as a legal body today, make that decision, and then perhaps give advice for landowners how they can alter things in the future.
That's what we normally do. So we've got a proposer. Have you got a seconder, Jack? I'll second it then. And can we have a vote on it, please, to go with the officer's recommendation? That's two of us. Against it? Are you against it?
I'm abstaining.
Okay. I'll go with the officer's recommendation. So that's passed. Yep. Okay, thank you. And we'll move on to item number 8, please, which is the S53 application for the addition of a public footpath from the highway to Chebsey, to the highway to Norton Bridge, Chebsey, and the application number is LJ612GD. David.
Yes, thank you, Mr. Chairman. I will move straight to the recommendation, which is that the evidence is sufficient to show that a public footpath may be reasonably alleged to subsist along the route marked A to B on the plan at Appendix B. The application rests on a North Staffs Railway Plan of 1872 and is supported by a near-contemporary Ordnance Survey Plan of 1880. In this case, the route is described within the bounds of Plot 1 as a public footpath, and the Surveyor of Highways is listed. Clearly, this annotation is good evidence that the route was indeed a public footpath. Good evidence, that is, for the lower test of reasonable allegation. The Surveyor of Highways are always good indicators of public rights, as indeed are the parish councils, where multiple landowners are recorded. Again, the limitation of railway plans is that they only show the section of the route that was to be affected by the proposed railway itself. Therefore, typically, only part of any route is expected to be visible on any plan. This is something your officers acknowledge, although it is not necessarily fatal to a claim based on reasonable allegation. And this, Mr. Chairman, is where the Ordnance Survey Plans offers, again, that clarity. In addition to the railway and Ordnance Survey Plans, the applicant highlighted the presence of the route on the parish survey card and plan of 1951. Here it is annotated as footpath 6 and is clearly depicted on the plan. The associated notes state, and I will quote, that footpath 6 left Norton Bridge, Shalford Road by a field gate opposite the Quaker farm and at the site of a duck pond. It proceeds to the left of the Quaker burial ground, an area enclosed by trees, and reaches the Chebsey Lane by rails, slightly above the point shown on the Ordnance Survey. These rails are left free of BW, and that is a reference to barbed wire. The parish survey card also states that the route started at Quaker Farm on Norton Bridge, Shalford Road, and finished at Chebsey Lane above the Quaker burial ground. The reason given for believing it was a public footpath in 1951 was dedication usage. In addition to this, the applicant supplied an extract from the book entitled Ripples of Time, a historical journey along the River Sow with Bruce Braithwaite. No date was given for the work, although a brief investigation by officers revealed it to have been published by at least 1987. Members can find this at Appendix G, and it must count as one of the most fascinating pieces of evidence your officers have ever seen. The book contains an unusual story about Shallowfoot, wherein a witness describes seeing the apparition of a 17th century Quaker using the alleged route. Your officers are referring to a ghost, Mr. Chairman, and this is probably the first time a ghost has ever been given as evidence in a Section 53 application. To elucidate further, an old 19th century map was consulted after the sighting of the ghost, and the route the ghost was using identified as the line of the alleged route. The ghost disappeared into a now unbroken hedge where a gate had formerly been. The book suggests the ghost was heading into the old Quaker burial ground on the far side of the hedge, and although interesting, the event is, of course, devoid of probity in many different ways. And while anything is possible in the universe, not everything is possible in English law. Turning to the landowner responses, we find that during the initial consultation stage, neither of the two landowners identified by the applicant submitted any evidence to support or refute the claim. Following the circulation of the draft report, several objections were received from the landowners concerned, the following statement being received from landowner 2. I think these 4 alleged footpaths should be extinguished because of the amount of stress and anxiety it causes landowners. Please put yourselves into our position to find out there is an application to reinstate a public right-of-way because it's shown on a map that's not an official record drawn over 100 years ago. Imagine this going down your driveway and past your kitchen window and through your garden. If this is allowed, it could open the floodgates to further applications, and the next time it might be your land. If it is allowed, there should be new rules drawn up so all alleged footpaths have to be declared by a certain date, giving a couple of years for applications to be made before a deadline. Otherwise, it's impossible to buy land in the future and rest comfortable with the purchase on the information available and be comfortable investing and developing the land where suitable. Apologies for the repetition in some of these applications, but we have to sort of restate the facts as given. Landowner 3 also stated there were other much more convenient routes in the vicinity, that these routes were more commodious for walkers, and that there would be no material advantage of adding this particular route to the network. Officers duly noted all of these concerns, although also explained that if the evidence did reveal the existence of a route, then something of sufficient probity, such as a legal stopping up order, would be needed to overturn it. Again, health and safety concerns, including the presence of a blind spot, were highlighted, and it was suggested that the alleged route would be more dangerous than other nearby alternatives. Potential antisocial behaviour issues were also highlighted, and it was felt that the route had no practical purpose. Again, members will be aware that none of these concerns have any probity under the law as it currently stands, and although they are noted, nothing turns on them. Chebsey Parish Council, interestingly, were not supportive of the route and were unaware of any recent use, adding that it would not be an asset to the local footpath network. This was at the time of the initial consultation, and their position remains unchanged. Conversely, the Ramblers Association supported the application, highlighting that Chebsey has a shortage of routes and going on to say that they supported any initiative to create or recognise public rights of way. This is essentially an addition on the lower test of reasonable allegation. We have a document indicating its status and a document indicating its extent, and this is ratified by a parish survey card and plan. As such, officers believe there is enough to satisfy the lower test and to recommend that the application be accepted and an order made to add the route as a public footpath to the definitive map and statement for the Borough of Stafford. Your officers further recommend that this should be to the minimum width of 1 metre throughout its length. Thank you, Mr. Chairman. Happy to take any questions.
Wow. We don't often have interesting ones like that. I mean, I didn't know there was such a thing as a Quaker burial ground, but to have the evidence submitted that a ghost sort of walked the path is a new one to me, and I'm sure it's a new one to you as officers. It does highlight the historic importance of Staffordshire, and obviously in that area we've got the Isaac Wharton cottage, and some real history obviously is there, but as I say, I'm quite shocked that we've now got a ghost telling us where we should be looking, but I'm glad that there is some solid evidence as well on this one. David.
Jim, following on from what you've said, I'm assuming that we don't have any written evidence from the ghost, and that the width or the surface will not have any relevance as far as the ghost is concerned. So we should consider only the evidence that's given by the officers. And on that basis, I would be happy to propose the officer's recommendation.
Thank you. Seconded from sorry, I'm still intrigued by this ghost story. Seconded by Jack. Yes, sorry, Jack. I've got this little thing buzzing around my head. So we've got a proposal from David, seconded by Jack. Do we have a yes, unanimous agree with the officer's recommendation? Thank you so much for that, David, and I'm sure you saved that one for last. Very interesting.
Yeah, officers were uncertain as to whether it would be user evidence or historical evidence. Obviously, the dead have no legal rights. But thank you. Thank you.
Yeah, very interesting. But aside from that, the fact that there's a Quaker burial ground down there, it does sort of, it's incredibly interesting. Right, now we'll move on to, have we got any items of, for exclusion to the public? We haven't. So can I therefore close this meeting? It's been an interesting one, as per usual. Some very interesting facts and figures put in front of us, and good discussion around what we do as a committee. So thank you all very much, and we'll close the meeting at 5 to 11. Thank you very much. All right, I can't see the camera, the clock that well. 11:05 on my computer. Thank you.